Well, hello everyone. I'm Jill Bloom, publisher of Walls and Ceilings, Roofing Contractor, and Building Enclosure. I'm here today with Art Aisner, the editor of Roofing Contractor. And the first time with us today, Hannah Belloli, the associate editor of Walls and Ceilings. And of course, Trent Cotney, CEO of Cotney Construction Law. Trent is one of the leading legal experts in the roofing industry, but also represents all contractors in the construction trades. Trent is an incredible advocate for contractors and very gracious with his time. So thank you very much, Trent, for your time today. And if you're not following Trent on social media, check him out because he always has great nuggets of insight to offer. But we need to kick off by addressing some major national legal news from just yesterday. Trent, can you comment on the Supreme Court's decision on sexual orientation and gender identity protections in the workplace? And do contractors need to update their work manuals or policies?
Yeah, so first off, thank you for having me. Jill, Art, Hannah, always a pleasure to be here. Really enjoy being able to talk to you guys. So yeah, we've been kind of tracking this case and some other ones, and every once in a while they slip one in where you're like, wow, okay, this is a big change. So let me tell you what was so critical about the decision that the Supreme Court made yesterday. Okay, normally Title VII, everybody's familiar generally with Title VII. And what that is it's a group of laws contained in 42 USC 2000. And what they do is provide that you can't discriminate on the grounds of race, color, religion, sex, or national origin. Now, here's what's interesting about what the Supreme Court did, is the Supreme Court took a look at it, and they said that that definition of sex includes gender identity. Okay, so you can't discriminate based on sexual orientation or gender identity. So they didn't create new law, they just interpreted what Title VII, the definition of sex is. The question has come up, and we've gotten a lot of phone calls, Jill, it's a timely question, is what do I have to do now? Do I got to change anything? Well, the good news is that the majority of the employee manuals that are out there, they already have the Title VII language that's in there. It's saying that you can't discriminate or harass anyone on the basis of race, color, religion, sex, national origin. So if that's the case, there shouldn't be any necessary revisions to your manual. But it's important that your HR professionals understand this decision and that the definition of sex now includes not only sexual orientation, but also gender identity. So it's critical that you do some training for your HR professionals so that if an issue comes up, you're able to address it.
Yeah, definitely. So we're going to switch gears a little bit here. But first, before we do that, I want to say how excited I am to finally get to be here. As Jill said, I'm Hannah Belloli. I'm the associate editor of Walls and Ceilings magazine. I've been watching Trent now for a little while on social media. So needless to say, I'm very excited to finally get the opportunity to talk about everything that's going on in the world with him and hear his legal insights on it. So like I said, we're switching the gears a little bit. So back to COVID. So we're seeing a spike in some cases in 22 of the states that have reopened. We're seeing a spike, and Arizona, Texas, and Florida are reporting their highest case numbers yet. So what are you hearing about that from contractors? Is it something that people are starting to worry about again?
So it's interesting, Jill and I were just talking about it right before we came on here, and my headquarters is in Tampa, so we're in Florida, and we had gotten very little, and now we're just starting to see a lot of cases. We have a lot of phone calls from contractors all throughout the state that have had crew test positive now. Before this, it was always, some other states that I was getting these calls from. Now I'm starting to see Florida and Texas a lot more, where I hadn't in the past, okay? So I think from a contractor standpoint, we've been through this before, okay? Don't get caught unprepared. Prepare for the worst, because politically, I think it's going to be very difficult for any politician to close businesses down again. I think it would be political suicide at this point, especially so close to November. But I could see it happening. If it gets to the point where hospitals are overrun and they're unable to meet the demand, you could see something like that. So my advice to contractors out there is, you've been through it before, you saw what worked, what didn't work, prepare for the worst. Okay, so assume that you have to send some of the employees that just started Back home again, you should already have the technology in place. You should already have the systems, the SOPs, the procedures needed to make sure that you can operate effectively. But here is something that I will mention though, okay? And I've alluded to this in some of the previous videos. Storm season is here, okay? It's here. And we have had massive torrential rain, rain, thunderstorms here over the last few weeks. When you combine that with the uncertainty of COVID, it can create a lot of stress and pressures for contractors that are out there. So making sure that you have the ability to communicate with your crew, with your suppliers, with your other vendors, manufacturers, that's going to be critical, especially during the next few months.
Mm-hmm. Yeah, definitely. So amidst all this, would you say that frustration with the Paycheck Protection Program funding applications and disbursements is growing? Like, what are contractors supposed to do now with all this?
So I think overall, especially since the revised sort of guidance was passed here recently that extended a lot of the deadlines, made it easier for small businesses, a lot of that frustration has kind of dissipated. Right now, contractors have the ability to apply for Paycheck Protection Program funds up through December 31st of this year. So it's important that if you haven't already applied, to apply. The key thing now that we're getting calls about is, forgiveness. That's the thing that people are focused on. And those deadlines were extended as well, but making sure that you've got the paperwork in place, making sure that you're putting your best foot forward to ensure that you're maximizing your chances of forgiveness are kind of what we're seeing now. That's kind of the frustration. And I encourage anybody, look, I'm not a math guy. I'll be the first to tell you, if I can't count on my fingers, I'm in trouble. So usually, I defer to my accountant or somebody that's a lot smarter than I am to help me with the math part of it. I encourage contractors out there to do the same thing. Lean on tax professionals, lean on your accountants to make sure that you're doing things right.
Yeah, I feel you. I'm also not a math. I always say I'm not a math, I'm in English. And everyone doesn't really sound like you're in English either, because that doesn't make sense. But but it does appear that there's further legislation coming in July. So have you been hearing anything about what that's going to look like?
Yeah, so that's all over the place. And there's a lot of political wrangling. And here's what I want to tell the listeners. That's, don't count on another check, okay? Because the unemployment news that came out recently where it said that unemployment had shrunk by a little bit, that's not the kind of news that congressmen and women want to hear when they're about to stroke another check, okay? And there's a large contingent, especially within the conservative politicians, that are against providing additional funding because of the national deficit. So I think there's going to be a lot of political wrangling there. The infrastructure bills, which I'm primarily concerned about, those have been pushed off a little bit because of this political wrangling, And originally what I had heard is there was going to be more stimulus before July 4th. Now they're kicking it to, let's see what happens July 31st, then we'll talk about it. So my guess is, although there have been some suggestions in the House, and I know the Senate's preparing their own thing, is that it's going to be a wait and see approach as more statistics and data come out, especially on unemployment. That's going to help drive the indicator. Now, there has been a big push politically that there's some frustration about the current state of unemployment benefits that are received. The extra $600 a week, some are arguing, creates a disincentive for certain people to go back to work. So I think that's part of the political play as well, because a lot of times, you're gonna, bottom line is there's just gonna be a hot mess. I mean, that's the legal way to put it, is it's gonna be a lot of political wrangling, and statistics are going to help drive where this thing goes. I do believe there will be some additional relief. What that looks like, whether it's checks to individuals, whether it's additional stuff for businesses, or whether it's an infrastructure type bill, remains to be seen, but stay tuned for more.
Thanks, Trent, and thank you, Hannah. Some great questions there. Trent, I want to pick up right there, talking about the infrastructure incentive legislation. So is the fact of this political wrangling, is that really the only holdup in terms of the funding or that creation? And if that's not the only holdup, is there still an uphill battle for roofers in particular, but really for all specialized construction systems to really be included in that legislation?
Yeah, so this is something that was interesting. I was talking to our lobbyist in Tallahassee the other day about some of these issues. We're looking at it from a state level, and we started talking about the national sort of framework. And the issue is that oftentimes in these infrastructure bills, keep in mind, I think you guys have been to Roofing Day, right? You go there, and when you talk to the politicians, a lot of it is educating politicians on what contractors do, okay? If you've never had your hands dirty, if you've never been in construction, then you may have a very different understanding of what a contractor is and the professionalism of our industry. And part of the problem with these infrastructure bills is when you say infrastructure, you're thinking roads, you're thinking bridges, you're thinking that kind of stuff, okay? Including vertical construction in an infrastructure bill is critical, but it's not an easy sell. And here's why, okay? We have tens of thousands of miles of roads and bridges and all that kind of stuff, which is very easy to put money into because they constantly need repair. Vertical construction, though, is relatively limited, okay? If you think about it from a federal standpoint, what they can, federal buildings, post offices, that kind of stuff, if it's a state infrastructure bill, same kind of things apply, schools, that kind of stuff, but there is not as much access to potential improvements. What's critical for lobbyists to do is to make sure that they are including some component for vertical infrastructure. And to your point, Art, I think that we will see this, but it's going to be on the tail end of whatever else happens. And again, I've said since March, my eye has been on September, October, November, December. It's still right there, okay? We're still in the honeymoon phase. I think there's a lot more to come. So yeah, I think it's coming, but the closer we get to November, there is going to be a lot of grandstanding, a lot of political gameplay that you're going to see. So I don't know what that's going to look like. It may be till after the election until you see something.
Well, they are moving ahead with some safety legislation. We've talked about OSHA multiple times and how they're suggesting contractors react to COVID-19. Specifically, though, there's been a emergency temporary standard that mandates some specific COVID-19 mitigation measures. Generally, I know you think more regulation is bad for contractors, but is that the same in this case? And how important really is it to designate those COVID-19 cases that you're now seeing more of in Florida?
So OSHA and the CDC have kind of worked hand in hand since this thing started. And OSHA came out with some initial guidance in April and then kind of amended that, I think, in May to make it a little bit more detailed. And they've had some smaller issues about return to work and things like that they've put guidance out. But it's important for everybody to understand out there that guidance is just that, it's guidance, okay? Now, generally, if OSHA tells me to do something, I'm doing it, okay? I'm not playing around with that, but it's not a rule, okay? So if we have, and we've had situations where OSHA might be pointing the finger at contractors for not complying, a defense that you've got there is, hey, this isn't a rule. So the unions and a lot of safety professionals have said, hey, OSHA, you're not doing your job. You need to step up. You need to give us some guidance in a rule form that can be enforced. Okay, we need to protect employees. And what's interesting is there was a suit that AFL-CIO filed and the DC Circuit Court. And on June 11th of 2020, they shot them down on the request for sort of this emergency temporary standard. Now, there is what I've heard behind the scenes is that there is additional attempts to try to get some standards in place. But the problem is that this is so fast moving that it's difficult to determine what the proper process is and the procedure is. And that's why you're seeing guidance. You're seeing a lot of, here's what we see now, here's what we will see, and as additional information comes out, you can expect to see some stuff like that. So from my standpoint, I speak for all my employees. I want all my employees to go home safe every night, and I think every contractor that's listening to this feels the same exact way. That being said, there has to be certain precautions that are taken. while business can still continue. And it's got to be a good balance between that. And I think that's sort of the rub there. So as this thing continues to progress, I would expect to see some more detailed guidelines, information, or even rules that come out. But right now, the best thing that contractors can do is engage in due diligence and make good faith attempts to comply with what's out there.
Right. I was going to ask you to kind of bottom line it for contractors there, because it is crucial that they document these potential COVID-19 cases, now, because it can be so hard to track down where an employee, may have contracted it when it comes to a workman's comp issue, or, I'm sure there's a lot more legal things contractors need to worry about, right?
So here's what's interesting, Arden, and if you think about it, if what OSHA is saying now in its recent guidance is they're saying that you have to be able to identify, you have to engage in due diligence to identify if an employee got COVID-19 while on the job. And if they did, then you have to report it on your OSHA logs. But here's the catch-22, and Jill and Hannah and Ara, I know you guys will be interested in this. If a contractor puts that on their OSHA log, then guess what? Workers' comp would also kick in, right? And that isn't necessarily beneficial for the contractor, okay? So here's the issue, is finding out exactly how somebody got it is very difficult. Now, you've got a good indicator if you've got a group of people that were working together that all came down with it. That's a good indicator they probably got on the job, right? If they are continually exposed to an environment where there's COVID-19, let's say they're working at a hospital, or they're working at a care facility or a nursing home where there was an outbreak or anything like that, good indicator, okay? Again, not 100%, but good indicator. And that's kind of what OSHA is looking for. So after the fact, let's say, I'll give you a hypothetical. Let's say you put down that your employee, you don't put it down because you believe they got COVID-19 elsewhere, okay? That employee ends up hiring a lawyer because workers' comp doesn't kick in to cover it, okay? That lawyer does some due diligence and is able to show, hey, I think you got it on the job, okay? What OSHA is going to look for is, hey, did you engage in the amount of due diligence necessary to determine whether or not they did it? What good faith steps did you take to do that, okay? And if somebody is able to point the finger at you, you better be sure you can defend that, I guess is what I'm saying. It's a very touchy situation there, because you are damned if you do and damned if you don't, to a certain extent.
Right. And in reality, we won't really know until, some time passes, months, even years down the road, until some of this stuff does get litigated we figure that out. Trent, great information as always. I really appreciate your perspectives. I'm going to toss it back to Joe.
Yes, thank you, Trent, as always. We really appreciate everybody watching and tuning in to all this great insight that Trent has to offer. If you need to contact us, make sure you go to either roofingcontractor.com or wconline.com and click on the Contact Us page. And we'd love to take any questions you have. But you can also easily touch base with Trent directly. Trent, you want to let us know what that is?
Sure. Go to tcotney at cotneycl.com. That's my email, or go to our website, cotneycl.com.
Thank you. And also make sure everyone signs up for, subscribe for free to our e-newsletters and our digital editions. And that's it for this time. We look forward to seeing you again. Take care.